We are so looking forward to today, and thank you all for taking the time out of your day and hopefully staying cool in today's weather. For those who do not know me, my name is Ashley Hoy. I'm a financial advisor here at Bickling Financial Services, and I'm so excited to welcome back Christine Boutin of Counsel with Myrick. Today, we're going to be going over creating and updating a basic estate plan. And Christine works very closely with elder clients to design an estate plan which advances asset protection, mass health benefits, nursing home care. But what she also does is that she represents families in court to obtain guardianship, make conservatorship of adults with disabilities, on personal, financial, and special needs medical planning. Christine kind of does everything, I feel like. Christine also probates wills and intestate estates. She guides personal representatives and trustees through complex estate administration and trust administration processes. And Christine, forgive me, are you able to see my screen? Want to make sure we're good.
I can, yeah.
Perfect. Yeah. So from here, I'll let Christine take it away.
Great. So this is a little bit about my firm. We are located in Worcester County. We're a full service law firm, but I am here in the Trust and Estates Department, specializing in elder law, estate planning, special needs planning, and trust administration. We can go to the next slide. And
I kind of went through that.
We do that. So we'll go to the next one. Okay. So we're just going to talk a little bit today about why do we do estate planning. We'll start with that. So basically, by doing estate planning, we are putting in writing our specific wishes about who we would like to receive our assets when we're gone. This is important for everybody. And it's not only who's going to receive our assets, but we can also put in there, if we have minor children, who do we want to be the guardians or the conservators of our minor children if something happens to us as parents and we're leaving these children behind, who do we want to take care of them? And it's not, when we think of estate planning, sometimes people will say to me, oh, but we don't have a lot of money, we're not wealthy, we don't need to do that. That is not at all true. We do estate planning for people at all financial levels. And it's not really about how much you have. It's about ensuring that whatever you do have goes to the people that you want it to go to. Because if you don't have your estate planning done, if you don't do these documents, then when you're gone, you're still going to leave, belongings and assets behind. But then they're going to be given to the people that state law says it's going to go to. And those might not be the people that you want them to go to. So it's really important to put your wishes in writing so that you can ensure your assets pass to the people you choose. So some, other reasons why we do this, we do estate planning, is to, if we have minor children, obviously they can't inherit outright if they're under 18. So we want to put trusts or other type of planning in place for them so they can inherit and have that money protected for them for once, they are adults. If we have loved ones with disabilities who may be on public benefits that they need to meet their daily expense, want to leave them assets or cash outright because that might affect their public benefits. So there's trust planning we do so they can still receive the funds, but in a safe and protected way. If we have family members who have substance abuse issues, financial sort of spendthrift issues, or going through a divorce, or some other type of a relationship breakdown, you may still want to leave assets to these people, but you want to be sure that you do it in a way where they're going to be able to receive the benefit of the inheritance, but it won't, it won't be subject to overspending or any other type of inappropriate use. We also do planning when we have elders who need to apply for Medicaid to pay for long-term care in a nursing home, and they want to protect the assets they have so they can pass what wealth they've accumulated on to the next generation, but still get eligible for Medicaid. So we do specialized planning for that. And then often we do trust planning because in Massachusetts we have an estate tax. And that means there is a tax placed on the value of your assets as of the date of death. if the value of your total assets is over 2 million, then the state is going to assess a tax on those assets before they can pass to whoever you have, named in your document, in your will or your trust to receive those assets. So, and 2 million people will say, oh, that sounds like a lot. We don't have that. But in Massachusetts, our home prices are high. So if we have a home, life insurance policy or two, and a home and a vacation property, that might, there you are at the 2 million, over the 2 million per person. So we do like to do planning to kind of minimize the effect of the estate tax on those assets. We can move on to the next one. So when we're talking about estate planning, what are you actually talking about? So these are the basic documents. We have a will. We have a durable power of attorney, which is for the purpose of that is to name somebody to make your financial decisions in the event that you become incapacitated and you can't make them yourself anymore. A healthcare proxy, which is similar to the power of attorney, but you're nominating somebody to make those medical or healthcare decisions for you if you're unable to do so. A living will, which is actually not a will. It can also be called an advance directive. Basically, it's your statement of your wishes regarding end-of-life care, what you would want and what you would not want. Our HIPAA release, which in the HIPAA, you're going to nominate anybody that you would want to have access to your health information. So it might be a situation where you're in the hospital, you have a large family. One of like your children is your healthcare agent, but the other family members obviously aren't your healthcare agent. So if they wanted to call the hospital and find out how you're doing, they can't do that unless you have them listed on the HIPAA release, and then the hospital staff knows it's okay to talk to them. So that's another basic document. And then we have trust, which is a huge category, and a 2-hour plus seminar in itself about all the different kind of trust planning you can do. But we'll talk a little bit about some basic trust planning that everybody should sort of consider as we go through this. So different ways to inherit. So when you pass away, you leave assets to people in different ways. And sometimes, people are doing things like filling out a beneficiary designation form on a life insurance policy. Now, they don't realize they're doing estate planning when they fill out that beneficiary designation form, but that's exactly what they're doing. So when people die, and this is Massachusetts, so if people die and you leave a bank account and it's just in your name alone, so that type of a bank account is going to need a court process. However, if you had named somebody else on your bank account, so commonly we'll see like parents and children as joint owners or spouses as joint owners on a bank account, that is going to immediately become the sole property of the surviving owner when the first owner passes away. So it doesn't need to go through will, it doesn't need to go to court. If you have a jointly owned bank account or a jointly owned house or piece of real estate, that will automatically, by operation of law, become the sole property of the surviving joint owner. Assets with a named beneficiary. So like we're saying, a life insurance policy, or sometimes like an investment account will have a beneficiary named on it. That also automatically passes to the named beneficiary when the account owner dies. So you don't need it to go through your will. You don't need to go through court. You just would supply the life insurance company with a copy of the death certificate and fill out some forms, and then the asset's going to be transferred to you as the named beneficiary. Assets held in a trust. So many times we'll have people who transfer ownership of their homes into just a simple revocable trust. And so once the house goes into the trust, then it's legally owned by the trust and not by the original homeowners anymore. So once it's in the trust, if the homeowners pass away, again, there's no court involvement. The will is not involved with this. The trust itself will name a trustee, a successor trustee who takes over after the original trustees, who are usually the original homeowners. When they pass away, the successor trustee steps in, and the trust will have directions in it about where the house is going to go. So it's going to go to the kids. The trustee just will pass the ownership by deed to the children. It goes through the trust, and it's not going to be going through the court system. So those are the main three ways that people pass assets outside of the court system: joint owner, named beneficiary, or transfer it into a trust. If you pass away and you have, say, a piece of real estate that is just in your name alone, that is going to have to go through the court process. It's going to have to go through the probate court in Massachusetts, because now that estate is it's really frozen because the sole owner died. There's no will to say who it's going to go to. It wasn't in a trust, so there's no trust to say who it's going to go to. There is no joint owner to automatically take ownership. So it's kind of frozen. And in order to get it out of the estate, you have, if there is a will, you file the will with the probate court. If there's no will, you still have to file for probate, but you're going to be filing for probate without a will. And so then we have the issue now where state law is going to step in to say where that house is going to go. And it may not be to the person that the homeowner would have wanted it to go to, but without a will or a trust, we have to look at state law, and it's going to go through the probate court. So wills. So when we are looking at a will, we are going to be thinking about a few things. So number one, it's a good thing that we're doing a will, because now we know that we're not going to leave it to the law to decide who's going to get certain of our assets, the assets that we die with in our name alone. So keep in mind, the will is not going to govern a bank account that has a joint owner. Even if in your will you put, I want my Citizens Bank account to go to my niece, if you had listed your nephew as a joint owner on that Citizens Bank account, it's going to go to the nephew, no matter what your will says. So just important to keep in mind, the will is going to pass only those assets that are in your name alone when you die. So the basic components of the will. Number one, you're going to be naming a personal representative in the will. So that is the same thing as what we used to call an executor, but in 2012, the law changed. Now we call it personal representative. They're going to be in charge of the will, making sure everything goes through the probate court appropriately and that the will is allowed by the court. Once the will gets allowed, then the personal representative is actually appointed and they can start to do their job. They can't really do anything until that court process is complete. And sometimes that takes a few months, which is why people say, oh, probate delay. So once the personal representative is appointed by the court, then they start to gather all of the assets that are in the decedent's sole name. They put that money into an estate account that they open up, and then they use that money to pay bills of the estate, which can be like funeral expenses. If there's a house, there'll be mortgage payments, real estate taxes due. Once all of the debts of the estate are paid, and in Massachusetts, a year has passed from the date of death, then they can make distributions to the beneficiaries that are named in the will. And if there's no will, then they make the distributions to the heirs at law, that the state law will tell us who those heirs are. And it's just important to know that there's that 1 year waiting period, because creditors have a year from the date of death to present bills to the personal representative of the estate for payment. So you have to pay the bills off before you can then make your full distributions. So that's what the personal representative does. So the second important class of people named in the will are the beneficiaries. So they're the people who are going to be receiving the gifts that the grantor of the will put in the will. If there's no will, again, then we'd be looking at the heirs. But if there is a will, we call them beneficiaries. And again, if you don't have a will, then it may not go to the beneficiaries that you would have chosen. It also can be a charitable organization. Well, a lot of times we'll have people leave charitable gifts in their wills. And one thing to keep in mind, and it's a common misconception, I think, because we'll see people who come in all the time and they say, oh, I want to do a will, I have to avoid probate. So it's just important to keep in mind, wills definitely do not avoid probate. They are made to go through probate. That is their sole purpose, is to go through probate and tell the court who you want to inherit your money, and not who the state says is going to receive your money. So go to our next slide. So now we have trusts. So again, there's so many different kinds of trusts out there. We're just going to talk about the two main categories today. So we have revocable trusts. So a revocable trust is a trust that you may set up, and you're going to retain full control over this trust at all times. You decide what assets are going to go into it. You decide what assets are coming out. You decide the distributions that you're going to make from the money that is in the trust. You can decide you don't want the trust anymore, and you can just revoke it and get rid of it. And so often people will set these up for just the simple purpose of avoiding probate, because any assets that you put into this trust are not going to have to go through that court process that is set, the probate court process. And that's because those assets are not going to be in the decedent's sole name at the time that that person dies. They're going to be in the trust and owned by the trust. So then the trust says where the assets go. So it does provide for probate avoidance and a very smooth and quicker transfer of assets to those beneficiaries after the grantor of the trust dies. So we also use these when I was speaking a few minutes ago about the estate tax. So we do use revocable marital trusts for estate tax purposes to try to reduce or maybe even eliminate any estate tax that might be due. That has to be done, well in advance. And we would, look at the asset totals and figure out how we're going to do it. But that is a way that we can reduce estate tax. We also use revocable trusts to hold assets for minors. So if you have minor children, you may decide to set up a trust for their benefit, so that if you pass away while they're still young, they will receive the assets into the trust, and then the trustee will be responsible for managing the money until they're adults at whatever age you choose for them to receive the money. We can also do irrevocable trusts for disabled individuals, or a number of other reasons, but these are the most common reasons. We have another category of trusts called irrevocable trusts. So these are trusts done for a very specific purpose, usually to shelter assets for a reason. If you are the person who sets up an irrevocable trust, you do give up the right to the equity of the assets that are in that trust, or the principal, because you are looking for the benefit of sheltering them so that they're not considered your asset for some type of a purpose, such as Medicaid. So if you have a revocable trust and you're applying for Medicaid, you're not going to be eligible, because Medicaid will say, well, you've got access to all this money, free access. You're going to spend it down. We're not going to cover you. If you put your assets into an irrevocable trust, that will lock them up, take them out of your ownership, and then they're not considered your assets for the purpose of these public benefits, but you'll still be able to retain some of the benefit of having these assets. So we do an income-only trust when we're talking about Medicaid or Mass Health financial eligibility. It avoids that payback by the state. So if you own a home and it's in your name, and you've been into a nursing home on Medicaid and you pass away with that home in your name, they will come back in a state recovery and try to force a sale to repay themselves for the amount that they have spent for your care in the nursing home. An irrevocable trust can avoid that. Another way that we do some Mass Health eligibility planning with irrevocable trust, this would be for if the elder had already sold the house and didn't have the house anymore, but had all the proceeds in an account. We can do an irrevocable child's gift trust, again, to try to protect those assets for the parents' financial and Mass Health eligibility. There are irrevocable life insurance policy trusts. So if you have a large life insurance policy, but you're trying to minimize the effect of the Massachusetts estate tax, you can do an irrevocable life insurance policy. We use irrevocable trusts to hold assets of people with disabilities who might be on a means-based public benefit like SSI, which has a $2,000 asset limit. But if that person was in an accident and they have settlement proceeds, they don't want to lose their public benefits. So we put them into a first party irrevocable special needs trust, and that way the trust can receive the money. It can be used for the person's benefit, but they're still going to keep their SSI and their Mass Health. And we can also do it for a different kind of a special needs trust, a third party supplemental needs trust, also for someone with disabilities. So that, again, that's just an overview of the type of trust that we commonly see in our trust and estates practice, and we do these a lot. And you may have heard the term living trust. And so you might say, well, what is a living trust and how is it revocable? Is it irrevocable? So when you hear the word living trust, all that means is that it is a trust that the grantor set up during their lifetime. It can be revocable or it can be irrevocable, but they're both living trusts because the person who created the trust, they signed it and they set it up during their lifetime. There is a type of a trust that is not a living trust. It's called a testamentary trust, and you would build it into your will. So when we draft somebody's will, we put the trust right inside the will. We do that for certain particular purposes, also often for Mass Health asset protection planning. But that type of a trust, even though they signed the will during their lifetime, it's not active until they die and it goes through the probate court, and the probate court allows it. So it's not functioning as a trust until after the person dies. So that is not a living trust. But these two type of trusts are, and one other quick thing to remember is doing the trust and signing it is only half the battle. And I'm sure Ashley has seen this in her years of financial planning, where you have a beautifully written trust that's lovely, signed with beautiful signatures, but then the creators never put anything into it. So setting it up is half of the battle, but then you have to fund it. And you fund it. So if you wanted your house to go into the trust, then we would do a deed from you to the trustee of your trust and record it at the registry of deeds. And that transfers the house out of your ownership into the trust. Now you funded it. If you have a bank account and you want to put it in your revocable trust, you take your original trust and go to the bank and you say, I want to transfer this, I want to open an account in the name of my trust and put some money in there. So they'll open up an account that's in the name of the trust, not in your name. And then you put the funds in that bank account, and now you have funded the trust. You have put money into your revocable trust. So very important. Remember, it's a two-step process. Actually signing the trust, creating it, and then funding it.
And Christine, you couldn't have said it better myself. So for anyone on this call who is wondering why at Bickling, we are always asking for your estate documents, where you are with your estate planning, when was the last time they were updated. These are all reasons why, because we work collaboratively with other professionals to make sure that your estate plan is working and working the way as intended. And I'm going to move on to the next slide just because it is 1:30 and we are getting quite a lot of questions in, which is excellent.
All right, we're going to move quickly. Durable power of attorney. This is another important document in your estate plan. So you're naming an individual who's going to be your sort of your agent, your voice, if you cannot handle your own money anymore. You've been in an accident, you're in a coma, you can't pay your own bills, pay your own taxes, you can't support your children. Named agent uses his power of attorney to step in and do all those things for you. We call it durable because it means it's only continues to remain in effect after you're incapacitated. And so there's other powers of attorney that don't do that, but durable does. We commonly do these, so we're going to prepare them so it's actually in effect once you sign it, because we can do it the other way, so it's not in effect until after incapacity, but that there's a delay, because at that point in time something might happen to you and your agent needs to move quickly and get access to your money, but they can't because a doctor has to say you've actually been incapacitated. They have to do that in writing. You have to attach that to the power of attorney before you can use it, and it results in delay, and the doctors have never seen this before. They don't know what you want them to do. So we generally always will do them so that they're in effect when they're signed, and then they're ready to be used right away if it's needed. The authority of the attorney, in fact, that's kind of the person you're naming to handle your financial decisions. And it generally covers any decisions that the person who's creating the power of attorney can do for themselves, but sometimes they can limit it. You want to choose an attorney, in fact, who's organized and makes good financial decisions in their own life, not somebody who struggles with finances. And we also say, please name an alternate, because if something happens to your primary attorney, in fact, and you don't have an alternate, then it can't be used. So you definitely want to have an alternate. Update every 5 to 7 years. Banks like to see them fresh. And also your attorney, in fact, is going to need that original power of attorney if something happens to you. And the bank's going to want the original with the wet signature, not a photocopy. So be sure that you keep it in a place where you tell your agent where you're keeping it. So we can move on now to healthcare proxies, similar to a power of attorney, but you are naming trusted family member or friend to be your decision maker in the event that, again, something has happened to you and you can't make your own healthcare decisions. You're naming the person you want to do that. So you will do the healthcare proxy now, but it's not going to be in effect until something does happen to you and you're in the hospital, the physician examines you and says, nope, can't make their own medical decisions, and writes it in your medical record. That activates the healthcare proxy. So then your healthcare agent at that time can start making your healthcare decisions. If you get better, when you get better, the physician will make a note in your chart saying they have recovered their capacity, and then the healthcare proxy goes back to sleep and you're back to making your own healthcare decisions. So when you're choosing an agent, you want to pick somebody who's good at evaluating complex information, because they might have to do a risk-benefit analysis about the type of treatment that the hospital is recommending, or a particular medication that could be helpful but has some serious side effects. And they should be someone who's calm under stress, because they may be getting a 3 a.m. call to say, hey, you need to decide this now. You're going to, again, name an alternate because you want to have a backup agent. And, you could do co-agents, but sometimes the people don't always agree, and that causes issues. So we have a primary and then an alternate. A lot of times people will recommend take a magnet, put a copy of your healthcare proxy on your fridge, because if anything happens and the EMTs come in, they're trained to look there. So that's a good place to put a copy, but do tell your agent where you're keeping your original, as they may need the original, if it's necessary. Our next slide is for living wills. So as we said, these are advanced directives. The healthcare proxy names who you're going to choose to make those healthcare decisions for you, but the living will talks about your preferences. So do you want to have that aggressive treatment right to the end, even if there's very little likelihood that you're going to get better and have, a good quality of life? Are there certain things you do want, other things you don't want? So do you want to have, tube feeding? Do you want fluids? Do you want, if your heart stops, do you want resuscitation? Do you want to be on a ventilator? So all of those things you need to think about to decide, if the time comes and you're incapacitated, what decisions do you want your agent to make? And so sometimes this living will language is built into the healthcare proxy, and sometimes it's a separate document. It kind of varies. And also the legality of the living will vary. So in Massachusetts, it is not a legal document. It is a set of guidelines for your healthcare agent to help that person make those decisions in this time of crisis for you.
And Christine, thank you for pointing that out, because we always get questions as well about this being an official legal document. But as you mentioned, it does vary by state. And a lot of people on this call, I'm guessing, may have vacation homes, second homes, etc. So in Massachusetts, this is not a legal document, but as Christine mentioned, it is a set of guidelines. So very important distinction between the two.
So our HIPAA. So the HIPAA, I think I just went over this briefly. If you have a number of people that would all want to know if you're in the hospital, how you're doing, it's good to have a HIPAA, list everybody on there. Then the hospital knows who they can and can't talk to. But the people on the HIPAA are not making your healthcare decisions. Only your healthcare agent makes those decisions. So our next slide is sharing your wishes with your agent. So you have done a healthcare proxy, named your agent, you ask that person first if they're willing to do it. That's important. And if they agree, then you put them down as your agent, but you still have to have a conversation with them about your wishes. And it's really important because nobody knows when that agent may be asked to step in and make some decisions. So it's good if they hear from you what you would like. So these are just some suggestions on how to start that conversation, because it can be difficult and it can be, challenging. And you may not want to address everything all at once, but just little, like have a few conversations and just do a little bit at a time. So you might just look at this and it kind of gives you some ideas about how to start that difficult conversation. The next slide. So life events that trigger changes to estate planning documents. So one thing to keep in mind is that you're never one and done with your estate planning. So the will and the trust and the healthcare proxy and power of attorney you did when your children were babies is not going to still work for you now that they're 25 and you are older in a different stage of life, and you may have more assets now than you did, back then. So you always have to update your documents to fit the stage of life where you're at. So these are just some ideas of life events that sort of trigger those changes. So your children and your grandchildren are grown up. So you probably don't need trust for minors anymore that you could have set up. You don't need the nominations of the guardians and the conservators for your minor children anymore. So that's a sign that you need to update your wills and your trusts. Divorce and remarriage, blended families. So when you get divorced, you want to change all your beneficiary designations on everything, because you probably don't want, the possibility even of, your ex-spouse getting your IRA. So you want to change all those beneficiary designations, and do a new estate plan. Because even though the law says that, once you're divorced in Massachusetts, if you still have an old will, any gifts or any nominations are just going to automatically be revoked to that prior spouse. But that kind of leaves your estate plan, half done if it's an old estate plan. So you want to update it. You get divorced, you get remarried, do a new estate plan, new will, new powers of attorney and healthcare proxies. You'll probably also, if you've gotten remarried, now you're in a second marriage. If your new spouse is also in their second marriage, you might both have children from prior relationships. So you want to redo your planning and do specific trust planning for a blended family, so that your trust plan is going to reflect gifts to your children from your prior relationship, and also some gifts to your current spouse. So planning for blended families is much different than doing just simple wills and trusts for a family where the spouses are each other's only spouse and the children are all the children of that marriage. Blended families are different. So you really need to update your estate planning. Disability, if you have a child with disabilities or a spouse who becomes disabled, you definitely want to look into supplemental needs trust planning, because what you want to do is you want to preserve any public benefits they may have, but also give them the ability to have some inheritance go to this special needs trust, so they can still benefit and receive money and or other benefits from that trust, but it won't be counted as their asset. Change of residence. People move all the time and they'll say, I've just moved to Massachusetts and I have my New York documents. Can you look at them? And so we'll look at them, and what we see is, we see healthcare proxies that aren't called a healthcare proxy. They have a different name. We see powers of attorney that are also called different things. And so we know that, if that healthcare proxy has to be used in a Massachusetts hospital, those doctors, they don't have time to say, oh my goodness, what is this? Is this the power of attorney? Is this the healthcare proxy? Because they'll have things like durable power of healthcare proxy. Well, what is that? So it's good to have them checked by an estate planning attorney in your new state. And also another life event is death. I mean, you're doing a will, you did it 30 years ago. Maybe the person you named as your personal representative predeceased you, or the beneficiary is predeceased you. So you definitely want to look at those and update them. So how do I keep on top of this? Review your documents every 5 to 7 years. Are there financial changes in your life? Are you in a different financial position now? Have your relationships with the people named? Did you name your sister as your personal representative, but you have a falling out and you don't talk to her anymore? So you need to update your will. Have your goals changed? So certainly the goals you had when your children were 3 are different from the goals that you have now when you're much older and your children are adults. Did a spouse or a beneficiary become disabled or die? And sometimes we'll see people come in who, they did not do charitable giving in their prior documents, but now they want to implement that. So that's a definite reason to redo your plans. So when to consider updates to your documents, you kind of went through these already. Marriage, divorce, children, adults, purchase of real estate. So you definitely want to look at, if you didn't put your house in a trust before, maybe setting up a trust now if you buy a new house. Moving, retirement, that is, you're moving to a different stage of life. You definitely want to redo your plan then, and chronic illnesses. So our last slide is what happens if you don't update your documents. So powers of attorney, the banks do not like to see them over 5 or 7 years old. So they may be more likely to reject those. And if they reject your power of attorney, or if you have done a power of attorney, but the agent, you didn't have a backup and the only agent has predeceased you. So in both of those situations, if you can't use the power of attorney, now you have to go to court and get a conservatorship. And with the healthcare proxy, same thing with the healthcare agent. If you named the people you named and they died before you and you didn't update it, now you can't use it. You have to, the hospital is going to want you to go to court, your family to go to court and get a guardianship over you. And both of those are time consuming and expensive and very stressful. So it's good to just keep those documents updated. And like we said, with the wills and the trust, remarriage, divorce, all those things will affect your will and your trust. So you want to, that is also, not good results if you don't update them. So just keep an eye on your documents and remember they should change with you. So that's the presentation for today.
Excellent. Thank you, Christine, because I know we are coming up on time, but we have a few questions. I think a couple of these you did cover, but the first question that we got in is there a statewide exchange on which all of these wills, powers of attorney, et cetera, are all hosted, or does someone just need to keep these documents handy in case they're needed?
So that's a great question. So no, there's no statewide exchange at this time. So a court will allow you to file a will for safekeeping if you want to do that, but not a healthcare proxy or power of attorney. We will generally recommend to people to, keep it in a locked box in your home, but make sure that your agents know where that's located and that they have a way to access it. Some people will still put them in a safety deposit box, but again, if you set up the safety deposit box in your name and you don't put the name of your personal representative on the box, they're not going to be able to get your will out, because when you die, then the bank's going to say, nope, it was only in their name and they're dead, so you have to get a probate. And now you think, oh no, but I need the will to get the probate, but I can't get the will because I don't have the probate. And it's crazy. So we do recommend you just keep them in a locked box in your home. Just make sure you tell people where you keep it, but you can also give photocopies to people. So you may want to keep the original safe, but you can give photocopies of your healthcare proxy or your power of attorney to the people that you've named in those documents.
Excellent. The next question we have is, when you do have a revocable trust, does the trust become a beneficiary in your will?
So you can do a pour over will, which means we do a will that connects to the revocable or even the irrevocable trust. So where in the will, we will normally say, in the will, there's two categories of assets. There's your personal property, which is like your household effects, your car, jewelry, things like that. We'll say, this goes all to my spouse, and if my spouse predeceases me, to my children. Then we have a category called the residue, which means everything that is not your stuff, anything else that you might own in your sole name that's not your stuff. That's where we say, I leave it to the trustee of the Mary Smith Revocable Trust, created contemporaneously with this will on this day of May 20th, 2026. And so that way, that revocable trust is a beneficiary of the residue of your will, which means that anything that is in that the will creator's sole name at the time that they die, that's all going to be scooped up and it's going to be put into the trust after death. So that way it still has to go through probate, because those assets were not in the trust, at the time of death. They were in the decedent's sole name, but they can go into the trust after the probate is done. And then the trustee can, have those assets to work with and distribute once they transfer from the estate into the trust.
Excellent. And Christine, for those, we do have a couple more questions, but they're a little more specific. So I will send a follow-up email to those who have asked some additional questions. But is this email address and phone number the best way for clients to get in touch with you if they have additional questions or
Yes.
Would like to make a consultation?
Yes, absolutely. That is my contact information.
Excellent. And for those who are still on the call in the last minute here, we will be hosting here at Bickling one additional webinar next week as part of our estate planning conversation. Christine was kind enough to come back last week. We discussed long-term care and mass health. If you would like a copy of that replay, please reach out to your Bickling advisor or to me, and I can send you a link to the replay. This webinar will also be available, hopefully in the next week or so, for replay. And next week's webinar will be at the same exact time, 1 p.m. on May 27th. And from there, we'll be going over gifting strategies, charitable giving, and other additional information regarding estate planning. We appreciate your time, Christine. As always, thank you so much for joining us. And everyone stay cool today. Bye-bye.